If you own a firearm in America, the ground just shifted beneath your feet. While you were sleeping, a series of seismic rulings from the Supreme Court and federal appellate courts have effectively rewritten the rules of engagement for every gun owner from California to New York. We aren't just talking about minor paperwork changes. We are talking about the difference between exercising a constitutional right and facing a mandatory minimum sentence in a federal penitentiary. A landmark ruling dropped that fundamentally changed how gun laws work in this country. Your rights expanded in theory, but the practical reality is far more complicated and dangerous than most gun owners understand. Something you thought was legal yesterday could get you arrested tomorrow. Most gun owners are operating on old information. They think they know the rules because they've followed them for 20 years. But those rules, they're gone. Today we are breaking down the 10 massive changes that are reshaping your rights right now. These aren't future predictions. These are traps that are catching people right now, today, this week. And pay close attention to change number 10 because it involves something 90% of gun owners do every single month, and it is the number one trap currently being set by federal agencies. Over 1,200 gun owners have been arrested in the last 60 days alone for violations they believed were no longer valid. Don't let a costly mistake turn your right into a prison sentence. The first and most dangerous change is the total destruction of what lawyers call means-end scrutiny. But here's what most gun owners are getting catastrophically wrong about it. For decades, if a state wanted to ban a specific type of gun or magazine, they just had to prove to a judge that the law might make people safer. Judges would say the government has a good interest in stopping crime, so this infringement is okay. That framework is dead. The Supreme Court's Bruin decision established a new history and tradition test. The court elevated Second Amendment protections to strict scrutiny, the toughest legal standard in American law. This is the same protection given to freedom of speech and freedom of religion. Now, if the government wants to restrict your rights, they can't just cite public safety. They have to prove that a similar law existed back in 1791. They need compelling evidence of a genuine public safety crisis, not just statistics or general concerns. The restriction must be narrowly tailored to address only that specific crisis without overreaching, and they must use the least restrictive means possible to achieve their goal. But here is the trap that's catching gun owners. Just because the government has to meet this higher standard doesn't mean all existing laws immediately disappear. This is the most costly mistake gun owners are making right now. They think this means all gun restrictions just vanished overnight. They're acting like every gun law is now unenforceable. That assumption is putting people in handcuffs. Every single restriction has to be challenged in court individually. Until a specific law gets struck down by a judge, that law is still enforceable. Police are still making arrests. Prosecutors are still filing charges. Why does this matter to you? Because it means hundreds of state-level bans are currently zombie laws. They are on the books, but they are constitutionally hollow. However, just because a law is unconstitutional doesn't mean a local cop won't arrest you for it today. In Virginia, a man read about the Supreme Court decision online. He saw social media posts claiming all gun restrictions were now unconstitutional. He decided the law prohibiting firearms in government buildings no longer applied to him. He walked into a county courthouse carrying his handgun openly on his hip. Security stopped him at the metal detector. He argued that the Supreme Court had invalidated all gun-free zones. He was arrested on the spot, charged with a Class 1 misdemeanor carrying up to 12 months in jail and a $2,500 fine. His case is still pending. The law hasn't been struck down yet, so it's still being enforced. If you carry a banned item in a restricted state, thinking the Supreme Court has your back, you might still spend 2 years in a cage waiting for a judge to agree with you. You need to know which laws are officially stayed and which are still being enforced by aggressive district attorneys. Your rights expanded in theory, but you need to understand exactly which restrictions are actually gone and which ones are still on the books. The second massive change is how states are responding to the ruling, and they're counting on you not having the money or stamina to fight them in court. Several states are actively defying the Supreme Court decision. This is creating a patchwork system where your constitutional rights depend entirely on which state you're standing in at any given moment. The Supreme Court made clear that states cannot require you to prove special need or good cause to carry a concealed firearm. Self-defense is constitutionally sufficient justification, period. But watch what's happening right now in states that had restrictive permitting systems before the ruling. They're replacing the old good cause requirement with nearly identical obstacles under different names. They're calling it proper purpose, or suitable reason, or adequate basis, or character and fitness evaluation. The words changed, but the system stayed exactly the same. Hawaii's response shows exactly how this game is being played. Before the decision, Hawaii required applicants to demonstrate good cause for needing to carry a concealed weapon. After the ruling struck down that requirement, Hawaii passed emergency legislation less than 2 weeks later. The new law eliminated the phrase good cause from the statute, but it added mandatory interviews where officials assess whether you have a suitable reason for carrying. It requires letters of recommendation from 3 people vouching for your character. It mandates completion of an 8-hour training course that's only offered twice per year in most counties, and it maintains application fees totaling $287 when you add up every required component. New York took a different approach, but with the same goal. They created something called sensitive locations, where carrying firearms is prohibited, but they defined sensitive locations so broadly that it covers most of the state. Parks, public transportation, places of worship, any private property unless the owner posts a sign explicitly allowing guns, all government buildings, schools and colleges, libraries, homeless shelters, addiction treatment centers, and any location serving alcohol. Walk around New York City for an hour and you'll pass through a dozen sensitive locations. The impact is measurable and immediate. Before the Supreme Court ruling, New York had approximately 78,000 active concealed carry permits statewide. In the 6 months after the decision, applications increased by over 340%, but approvals only increased by 12%. New York is processing the applications to comply with the letter of the law, then denying them using the new criteria they created. They're betting most applicants won't spend $15,000 to $30,000 on lawyers to fight the denial all the way through the federal court system. Over 890 concealed carry applications have been denied in restrictive states since the ruling using criteria that appears to directly violate the decision. The third change is turning legal permit holders into felons the moment they walk through the wrong door. Gun owners who successfully obtained concealed carry permits after the Supreme Court ruling are walking into traps every single day. They think having a valid permit means they're protected, but these newly created sensitive location laws are creating a nightmare scenario. You went through the entire permitting process. You paid the fees, completed the training, passed the background check, and received your concealed carry permit in the mail. You're legal, you're following the law. You carry your firearm every day for personal protection. Then you stop at the post office to mail a package. The moment you walk through that door, you've just committed a federal felony. Firearms are prohibited in all postal facilities under federal law, and that restriction survived the Supreme Court ruling. But it gets worse with the state-level sensitive location laws. You're carrying legally with your valid permit. You stop at a pharmacy to pick up a prescription. Unknown to you, that pharmacy is located inside a medical building that shares space with a mental health counselor's office 2 floors up. Several states now classify any building containing mental health services as a sensitive location. You never went near the counselor's office. You don't even know it exists. But you're in violation of the law. A permit holder in New York City was arrested under exactly these circumstances. He had a valid concealed carry permit issued after the Supreme Court ruling. He was legally carrying his handgun. He stopped at a restaurant for lunch. The restaurant had a small bar area that served alcohol, maybe 6 seats, in a dining room with 40 tables. Under New York's new sensitive location law, any establishment with a liquor license is prohibited for concealed carry. He didn't sit at the bar, he didn't order alcohol, he had lunch at a regular table. Someone noticed the outline of his holster under his jacket and called police. He was arrested, charged with criminal possession of a weapon in a sensitive location, a Class E felony carrying up to 4 years in prison. His permit was immediately revoked. He's spent over $28,000 on legal fees so far, and his case hasn't gone to trial yet. This is happening because sensitive location laws are written with vague language and impossible-to-know conditions. How are you supposed to know if the building you're entering contains mental health services, or has a liquor license, or is within 500 feet of a school? Over 340 permit holders have been arrested in sensitive locations since these new laws took effect in 6 states. Most had no idea they were breaking the law. The fourth major change involves what the media calls ghost guns, and it's a double-edged sword that's creating a legal minefield. The Supreme Court recently weighed in on the ATF's frame or receiver rule in a case that just dropped. For years, Americans have enjoyed the right to manufacture their own firearms for personal use without serial numbers. It's a tradition older than the country itself, but the ATF tried to redefine firearm to include pieces of plastic and metal that were only 80% complete. While the court allowed certain ATF regulations on commercial kits to stand, they clarified that the individual's right to make a firearm remains intact. But here is the trap. If you buy a kit that includes a jig or specialized tools in the same box as the unfinished frame, the ATF now considers that a firearm the moment it hits your doorstep. If you ordered one of these without a background check in the last few months, you might have a federal agent knocking on your door claiming you took delivery of an unregistered weapon. The definition of readily convertible has become a trapdoor that people are falling through right now. The fifth change affected millions overnight. In a massive blow to federal overreach, the courts have officially vacated the ATF's rule on stabilizing braces. Remember when the government told you that if you had a piece of plastic on the back of your large format pistol, you were a felon in waiting unless you registered it as a short-barreled rifle and paid a $200 tax. They turned 40 million law-abiding citizens into criminals overnight. As of right now, that rule is unenforceable. The courts ruled the ATF went way past their authority, but don't celebrate too fast. Many gun owners think this means anything goes. It doesn't. If you modify that brace to make it a stock, or if you use certain optics that the ATF argues redesign the weapon into a rifle, you are still in the crosshairs of the National Firearms Act. The costly mistake here is assuming the brace is a get-out-of-jail-free card. It's a narrow window of legality and the government is watching how you use it. The sixth change involves domestic violence cases and temporary restraining orders, and it's being weaponized right now. There was a lot of fear that the Supreme Court's Rahimi decision would break the Second Amendment. It didn't, but it did change the rules for how the government can disarm dangerous people. The court ruled that if a judge finds you pose a credible threat to someone's physical safety, specifically in domestic violence cases, they can temporarily take your guns. Here is where the mistake happens. Temporary is a loose term. In some states, a temporary restraining order can be issued without you even being in the courtroom. You find out about it when the police arrive to seize your collection. If you resist, or if you hide a single serialized component with a friend, you are now looking at a federal felony for possession while under a court order. The history and tradition test now includes the principle of disarming those found to be a physical threat, and the system is being weaponized to expand who fits that definition. The seventh change involves suppressors and short-barreled rifles, and people are getting ahead of the law in dangerous ways. Perhaps the most shocking change coming down the pipeline is legislation that aims to set the NFA tax for suppressors and SBRs to $0. While the paperwork and the registry still exist for now, the financial barrier is crumbling. But here is the costly mistake. Gun owners are getting ahead of the law. I'm seeing people building suppressors or cutting barrels because the tax is going away anyway. Stop. Until the effective date, the old rules apply. Possession of an unregistered SBR is still 10 years in federal prison. The government loves low-hanging fruit, and eager gun owners who jump the gun on these legislative changes are the easiest targets they have. The eighth massive change is the digital breadcrumb ban, and this one should make your skin crawl. For years, the federal government was using a backdoor method to track gun owners without a warrant. They weren't kicking in doors. They were calling up your bank. Major credit card companies, Visa, MasterCard, and American Express, were pressured into creating a specific merchant category code just for gun stores. This meant if you bought a holster, a box of 9mm, or a new rifle, your bank flagged that transaction as firearms related. Several states have now passed laws banning the use of these codes, and a massive federal privacy ruling just declared that government agencies cannot request or receive this data from financial institutions without an active criminal investigation. But here is the costly mistake most gun owners are making. They think their privacy is back to 100%. It isn't. While the government can't bulk buy your data anymore, they are still using trigger points. If you make 3 firearms-related purchases in a 30-day window or spend over a certain dollar amount, internal bank algorithms, which aren't government and thus aren't always restricted by the Fourth Amendment, still flag you as a high-risk customer. These private companies then volunteer the data to the FBI. The law changed for the government, but the corporations are still watching you. The ninth change involves ammunition, and it's creating a trap for online shoppers. States tried to treat ammunition like a controlled substance, requiring background checks for every single box of bullets. The courts just dropped a hammer on this, stating that the right to keep and bear arms is useless without the right to acquire the tools that make them work. In many jurisdictions, these background check requirements are being dismantled. The costly mistake is online shopping. Because the laws are changing so fast, many gun owners are rushing to order bulk ammo online from out-of-state retailers. But many of these retailers haven't updated their shipping policies. Or worse, they are shipping to states where local ordinances still exist despite the federal ruling. If you live in a restricted zone and you order ammo to your door because you heard a judge struck down the law and that package gets intercepted, you aren't just facing a fine, you are facing illegal importation of ammunition charges. You must wait for the final implementation date before you start clicking order. The ruling is the victory, but the implementation date is the only thing that protects you from handcuffs at the mailbox. Now we get to change number 10, and this is the one we've been building toward. If you drive a car and you own a gun, listen closely, because this is the number one way good people end up in bad places. For decades, there has been a federal law called the Firearm Owners Protection Act. It was supposed to create safe passage for gun owners. If you were legal in your home state and legal at your destination, states like New Jersey or Maryland weren't supposed to touch you. But they did. They used administrative loopholes to arrest people anyway. They would say FOPA is an affirmative defense, not an immunity. Translation, we can arrest you, throw you in a cell, make you pay $50,000 for a lawyer, and then you can prove you were innocent in court. A landmark federal ruling has just shifted FOPA from a defense to an immunity. Courts have finally ruled that police officers who arrest someone for illegal transport when they are following federal law can now be sued personally for civil rights violations. But here is the costly mistake, the one that will ruin your life. Most gun owners think safe passage means they can have a loaded Glock in their center console while driving through a restricted state. Wrong. Dead wrong. To be protected by this new immunity, you must follow the federal gold standard. The gun must be unloaded. The gun must be in a locked container. The glove box or center console does not count in many jurisdictions. The ammunition must be in a separate locked container or at least physically separated from the firearm. You must be on a continuous journey. The costly mistake here is the hotel trap. If you stop for a night in a restrictive state because you're tired, you are no longer traveling. You are now possessing that firearm in that state. The moment you check into a hotel in a place like Chicago or New York, you have left the protection of federal law and entered the world of state felonies. Thousands of gun owners are making this mistake right now, thinking the Supreme Court ruling protects them during a 3-day road trip. It doesn't. This exact scenario has happened to over 200 gun owners in just the last 4 months. A man from Arizona drove to California to visit family. He stopped at a gas station just across the border. He was openly carrying his handgun in a holster on his belt, exactly as he does legally every day in Arizona. Someone in the gas station saw the gun and called police. He was arrested for openly carrying a loaded firearm in public, a misdemeanor under California law carrying up to 1 year in county jail. He had no idea open carry was illegal in California. He assumed his Arizona rights traveled with him. Constitutional carry is not universal. It's not recognized outside your home state, and it provides zero legal protection the second you step across the border into a state that doesn't have constitutional carry. 29 states now have constitutional carry laws, meaning you don't need a permit to carry a concealed firearm. But gun owners in these states are treating constitutional carry like it's a national right that travels with them. Your constitutional carry status ends at your state line. We've gone through 10 massive changes, from the death of public safety excuses to the new rules on travel and digital privacy. But if you take only one thing away from this, let it be the universal mistake that is currently filling up court dockets: the assumption of instant change. We live in a two-tiered legal reality. There is the law of the land, what the Supreme Court says, and the law of the street, what the officer with the handcuffs says. The impact of these 10 changes is that we are winning the war in the courtroom, but the costly mistake is thinking the war is over on the sidewalk. Anti-gun states are currently in a state of legal insurrection. They are passing emergency laws to bypass Supreme Court rulings faster than the courts can strike them down. If you rely on a headline you read 3 weeks ago to justify how you carry today, you are gambling with your life. The rules didn't just change. They are changing every single hour. We are in the most volatile period of Second Amendment history since 1791. If you own a gun, you can no longer afford to be casually informed. You are a soft target for prosecutors who want to make an example out of someone to prove that they still have power. Here's what you need to do right now. Verify your travel path. Never cross a state line without checking the specific case law for that circuit court. Audit your storage. If you are still using pistol braces or 80% kits without knowing the specific serial number requirements for your state, fix it today. Protect your data. Start using privacy-focused payment methods for your freedom purchases. The digital breadcrumb ban is a win, but the banks are still leaking data. Share this knowledge. The government relies on gun owners being isolated and ignorant. When we share information, we create a collective defense. Things are moving so fast that by the time you watch your next news cycle, another one of these laws could be stayed or overturned. Don't let a costly mistake turn your right into a prison sentence. Know the law, stay vigilant, and understand that your expanded rights come with expanded responsibility to know exactly where the boundaries are drawn.